This is not an exaggeration or a hyperbole. Signing the Omnibus spending bill on March 23, 2018, Trump did his worst disservice to the American people during his presidency. That's because with the bill, he also signed into law an act that completely rewrites the democratic principles of the criminal justice system. With one signature, all Americans and many more millions of people around the world have lost their protection from unreasonable search and seizure. No probable cause is needed to access their personal information from now on, and the presumption of innocence has just acquired a fresh new design. Guilty until found evidence. This is what the controversial Cloud Act is going to mean for you. The Clarifying Lawful Overseas Use of Data Act is a bill that enables the US government, or any other foreign government the United States has surveillance partnerships with, to obtain private user data without a warrant or a probable cause. The US or foreign law enforcement would obtain the user data directly from private companies without notifying the individual or the law enforcement of said country. Of course, the bill manages to mention that foreign governments shouldn't intentionally target US citizens, but that's not how this works on the ground. Remember the Section 702 extension that gave Trump unlimited surveillance power over US citizens? It's illegal for the government to target its own citizens. So the Section 702 of the FISA bill allows the government to collect private data of American people from surveillance of foreign targets that might share a communications vector with those American people. This bill works in reverse. Prior to the Cloud Act, if US persons had their data held in overseas data centers of an American company like Facebook, Apple, or Microsoft, companies could have defended against complying with such data requests by citing overseas protections in a foreign jurisdiction. Cloud Act changes everything. It strips away American companies of any protection from unwarranted data requests. Under the Cloud Act, the US government doesn't have to go to court or ask the foreign government to compel a data disclosure. They go directly to the US company, and Cloud Act legally obliges them to comply. But the way Cloud Act is framed also allows foreign governments to go to US companies with such data requests. All they need to say is that their intent is a foreign target. But given the nature of online communications, that can expand to surveillance of millions of innocent people. If you struggle to grasp how foreign surveillance affects interception of domestic communication, the Snowden movie offers a great explanation.
So while they may be intending to target someone associated with a foreign government or someone that they suspect of terrorism, they're collecting your communications to do so. Because even if you're not doing anything wrong, you're being watched and recorded, and the storage capability of these systems increases every year consistently by orders of magnitude, to where it's getting to the point you don't have to have done anything wrong. You simply have to eventually fall under suspicion from somebody, even by a wrong call, and then they can use the system to go back in time and scrutinize every decision you've ever made, every friend you've ever discussed something with, and attack you on that basis to sort of derive suspicion from an innocent life and paint anyone in the context of a wrongdoer.
To visualize better how Cloud Acts could be abused by foreign governments on the ground, the EFF provides an exemplary demonstration. London investigators want the private Slack messages of a Londoner they suspect of bank fraud. The London police could go directly to Slack, a US company, to request and collect those messages. The London police would not necessarily need prior judicial review for this request. The London police would not be required to notify US law enforcement about this request. The London police would not need a probable cause warrant for this collection. Predictably, in this request, the London police might also collect Slack messages written by US persons communicating with the Londoner suspected of bank fraud. Those messages could be read, stored, and potentially shared, all without the US person knowing about it. Those messages, if shared with US law enforcement, could be used to criminally charge the US person in a US court, even though a warrant was never issued. This treatment is a galactic mile step backwards. It enables law enforcement to keep digging into private data of people until they find whatever slightly incriminating evidence about them. With Cloud Act in existence, people are no longer treated as citizens, but as enemies of the state. Maybe you are asking yourself, how did all this happen? In 1986, the US Congress approved the Stored Communications Act that required that service providers disclose their electronic communications like phone records and user data. Fast forward today, cloud computing and cloud services emerge and data are now stored internationally, which the SCA did not cover. That means the US law enforcement has no legal teeth to require US companies to hand over data produced in clouds hosted abroad. This manifested itself in the case the United States versus Microsoft Corporation, where Microsoft contested the government's request to access emails of a suspect in a drug trafficking case. Microsoft lost the case in the New York District Court, but appealed for the Second Circuit, which ruled in their favor. Microsoft did hand over account details to the US government, but argued that accessing emails stored abroad is outside of the US jurisdiction. The US government appealed to the Supreme Court, where hearings started in October 2017. 3 justices of the Supreme Court suggested that the issue should be resolved legally rather than judicially. On February 6, 2018, Senator Hatch and Representative Collins introduced the Cloud Act for the first time. Microsoft all of a sudden applauded the legislation and reiterated its unquestionable support. More than anything, we now need governments to move forward quickly to put new international agreements in place. The ultimate goal, one that is likely to take some additional years to achieve, is a set of agreements that create an accepted model and establish clear international legal rules that satisfy law enforcement and privacy advocates alike. It is 8 p.m. March 22, 2018, the night before the congressional vote on the Omnibus. The Cloud Act, which had never been vetted nor had it received a hearing, is added to the bill without any review or committee markup. Given that every congressperson had only a minute per page if they wanted to read through the 2,232-page document, it is safe to presume the majority of them were not even aware of the bill, except for Rand Paul and Ron Wyden. And in April, Microsoft dropped its case in Supreme Court. This is how the US government built a backdoor into Fourth Amendment for foreign governments to spy on their own citizens. So what can you do? You need to avoid services provided by US companies or companies residing in one of the US surveillance partners. These include all of the 5 Eyes, 9 Eyes, and preferably even 14 Eyes countries. The absolute red flag are Australia, Canada, New Zealand, the United Kingdom, France, and Israel. These countries can be considered as enemies of the internet. Switch to an encrypted email provider. The best option is ProtonMail, Postio, Tutanoda, and Disroot. Whenever you need to use a cloud storage, encrypt everything with Cryptomatter. Use encrypted instant messengers like Signal, Wire, or CryptoCat. Be vigilant. Privacy you lose today will be abused by someone in a few years' time. It happened before, it will happen again. That's why they do it. Thanks for watching. If you like the video, please engage in a discussion by commenting below and sharing the video with your friends. If you are new to this channel, you're welcome to subscribe.